Donald Trump is back in court for the third day of his civil fraud trial, but this time he is under a gag order. The judge in this case ordering Trump not to speak publicly about his staff and threatening him with fines if he does. This after Trump posted a photo of the judge's clerk on social media posing at an event with Senate Majority Leader Chuck Schumer. And our Lindsay Reiser's outside the courthouse. Lindsay, Trump's gotten in trouble for talking about cases before, but this goes further than a warning. What exactly are the rules now? What happens if he breaks them?
All right, Anna, the judge saying that he doesn't tolerate any attacks against members of his staff and said yesterday, consider this a gag order from here on out on any attacks against my staff. And he says that there will be sanctions if that's violated. Now, Trump came in today. The attorney general's also inside the court, and he didn't attack members of his staff, but he once again in front of cameras attacked the attorney general. In fact, calling her a political animal. He's called her derogatory terms in the past, just as recent as...
I want to use what you just watched as an entry point into the Nixon analysis because it illustrates something specific that the Nixon comparison tends to gloss over. Watch the behavioral sequence in that clip. A judge imposes a gag order with specific language. No attacks against court staff. The defendant walks out of court and immediately attacks someone adjacent to court staff, the attorney general, using language that falls just outside the specific boundary the order establishes. He found the precise edge of what the language covered, and he attacked the adjacent target instead. That is not impulsivity. That is a documented behavioral pattern. It is the same pattern that produced 10 contempt findings in the hush money case. Not 10 instances of the same violation, but 10 iterations of the same dynamic. An order is imposed, the boundary of the order is tested, conduct continues up to or just short of the specified limit, the court escalates, the boundary is tested again. Now, and here is where the Nixon comparison becomes analytically interesting. Nixon's behavioral pattern was structurally different. Nixon's instinct, when under pressure, was to conceal, to contain, to manage the information environment through secrecy, through loyal operatives, through legal barriers that kept the most damaging evidence from becoming public. The Watergate tapes were not public because Nixon was concealing them. His entire legal strategy was defensive. Keep the evidence inside, prevent disclosure, hold the line. Trump's documented behavioral pattern runs in the opposite direction. His instinct is to attack publicly, loudly, and in ways that generate maximum visibility. He does not conceal, he escalates. He does not manage the information environment through secrecy, he floods it with noise. That behavioral difference is not just stylistically interesting. It has structural implications for how the relevant accountability mechanisms apply. And those implications are part of why the Nixon parallel, while genuinely instructive, does not map cleanly onto the current moment. Let me show you exactly where it maps and where it breaks.
I actually want to get right to Kara Scannell. Kara, do we have a ruling in the Donald Trump civil fraud trial case?
Yeah, we do, Boris. We just got the ruling. It is 92 pages long, and I'm scanning through it right now. But when I'm looking at these numbers, the totals that the judge is ordering collectively in the case, so this will include all of the defendants, I'm getting a total of $362 million. And I'm just scrolling through this now. I can see that there's the dollar amount specific to Donald Trump. I'm going to use a calculator to do some rough math. It gets us to, for Donald Trump, about $354 million. That's for him, the company, the Trump organization. So very close to what the New York Attorney General's office was seeking of $370 million. There's a lot of zeros here and a lot of other numbers, but roughly $354 million is the judgment against Donald Trump. The judge also found that his son, Eric Trump, is lying.
That is the framework. 3 factors: specific, documentable, sequential. And I want to be analytically honest with you about something that takes a degree of intellectual discipline in the current political environment. When you apply that 3-factor framework to the current moment with the same precision that the original analysis deserves, the picture is not what most of the commentary is telling you. Let me run each factor. Supreme Court elimination of legal protection. In Nixon's case, this factor was specific and catastrophic. The Supreme Court's unanimous 8-0 ruling on July 24, 1974, United States versus Nixon, did not merely constrain executive authority. It destroyed the legal barrier protecting the single most damaging piece of evidence in the case, the White House tapes. Without that ruling, the smoking gun conversation, the June 23rd, 1972 recording establishing Nixon's direct participation in the cover-up 6 days after the break-in, stays hidden. With that ruling, it becomes public. And when it becomes public, it ends everything. That is what the first Nixon factor actually was. Not a general pattern of judicial constraints on executive power. Not a series of rulings that limited the administration's policy agenda. A single ruling that specifically and irreversibly eliminated the legal barrier protecting the decisive evidence. Now apply that standard to the current documented record. Chief Justice Roberts has established a pattern of constraining executive overreach that is real and documented. The tariff usurpation ruling, constraining the administration's trade agenda. The deportation due process ruling, constraining the immigration enforcement approach. Roberts' public statements defending judicial independence against executive attack. These are genuine, documented institutional constraints. They represent the Supreme Court functioning as the framers intended it to function against executive overreach. But here is the honest analytical observation. None of them is equivalent to the United States versus Nixon ruling. The reason is specific. None of those rulings eliminates legal protection over decisive evidence in a criminal proceeding against Trump personally. The tariff ruling affects policy. The deportation ruling affects enforcement procedure. They are significant. They are real. But they do not expose a smoking gun the way the Watergate tapes ruling did. There is one additional documented fact that must be stated with the same precision. The Supreme Court's 2024 immunity ruling, handed down in Trump versus United States, went partially in Trump's direction. The court established substantial immunity for official acts. That is documented. It is in the permanent record, and it cuts against the first Nixon factor rather than toward it. I am not editorializing. I am describing what the institutional record shows. The documented trajectory of Supreme Court rulings constraining executive overreach is real and developing. The specific elimination of legal protection over decisive criminal evidence that constituted Nixon's first factor is not yet present in the same form. Congressional mathematics becoming untenable. In August 1974, Nixon's own internal count showed fewer than 15 Senate votes for acquittal. He needed 34. The mathematics were not unfavorable. They were mathematically catastrophic. There was no path. Apply that standard to the current documented record. Republicans currently control the House. Democrats do not have the votes to pass articles of impeachment without Republican crossovers. The December 2025 House impeachment vote produced 140 documented votes, a floor as the source analysis correctly identifies, not a ceiling. In the Senate, the second Trump impeachment trial produced 7 Republican votes for conviction, the most bipartisan impeachment conviction vote in American history in terms of the percentage of the majority party crossing over. But 7 is not 17, and 17 is not the 34 that would be required to remove. The gap between 7 and 34 is not a rounding error. It is a structural gap that the documented record does not yet show signs of closing at the rate required. The 5 Republican senators who voted for war powers constraints are a documented data point. They are significant as a directional signal. They are not significant as evidence that the congressional mathematics have approached the Nixon threshold. I want to be honest with you about what this means analytically. It does not mean the documented pressure on congressional Republicans is inconsequential. The approval ratings, 42% 3 months into the second term, are a documented data point. The 23-point swing among non-college voters is a documented data point. The economic promises that have not materialized are a documented political liability. All of those factors affect the political calculation for Republican members in competitive districts. But political calculation is not the same as mathematical inevitability. Nixon's congressional mathematics were not unfavorable. They were terminal. The current congressional mathematics are unfavorable, but not yet terminal. That distinction is analytically significant. Factor 3. Partisan leadership withdrawal. This is the factor that is most clearly absent from the current moment, and I want to be precise about why it matters so much. On August 7, 1974, Barry Goldwater, Hugh Scott, and John Rhodes drove to the White House and told Richard Nixon directly that the game was over. Not through leaked statements, not through anonymous sources, not through votes on individual policy questions. They told him in person, with the explicit authority of the Republican Party's congressional leadership, that he had 15 Senate votes for acquittal, that the party could not protect him, that resignation was the only path that avoided the full constitutional spectacle of removal by force. That meeting, that specific documented face-to-face withdrawal of partisan protection, is what converted Nixon's situation from under severe pressure to untenable. Now look at the current documented record on this factor. Trump's Republican support in Congress shows documented cracks. The 5 senators on war powers, the Mitt Romney precedent, already established from the first impeachment, occasional public statements of concern from Republican members in competitive districts. These are real. They are in the record. But no Republican congressional leader has walked into the White House and delivered the Goldwater-Scott Rhodes message. No senior Republican has publicly stated that the party cannot protect Trump, that the Senate votes are not there, that the political mathematics have become untenable. The cracks are documented, the withdrawal is not. And here is the precise reason this matters structurally. Voluntary resignation, the Nixon path, is an action taken by the person being pressured. Nixon resigned not because the courts forced him out, not because the House impeached him, but because the combination of all 3 factors made staying politically and institutionally unsustainable. The partisan leadership withdrawal was the factor that converted sustainable under severe pressure into unsustainable. Without it, the other 2 factors alone, even in Nixon's case, might not have been sufficient. The documented absence of the 3rd factor is not a minor qualification to the Nixon parallel. It is a load-bearing structural observation. What is actually building the honest assessment? I want to be precise here, because I am not arguing that nothing significant is happening. The documented record across this series is real, and it is consequential. What I am arguing is that significant and consequential is not the same as convergent at the level Nixon required. Here is what the documented record shows is actually building. The Engoron findings are permanent. $354 million judgment, 3-year business bar, forward-looking fraud risk finding, hollow and untrue on the sworn testimony. These are in the record. They do not expire. Every subsequent proceeding that examines Trump's conduct has access to those findings. The contempt pattern is escalating. 10 findings in the hush money case, written warnings about potential incarceration that are active and documented, a behavioral record of testing every order's boundaries that is creating a compounding paper trail across multiple jurisdictions. The institutional resistance is widening, multiple independent courts. Roberts' documented pattern of constraining executive overreach, military leadership maintaining constitutional oath over personal loyalty, professional organizations formally condemning conduct as unlawful, the Chief Justice publicly defending judicial independence. These are convergent institutional signals, not coordinated, but pointing in the same direction. The political foundation is eroding in measurable, documented ways. 42% approval rating at the 3-month mark of the second term. 23-point swing with a key demographic. Economic promises under-delivering against documented commitments. Republican members in competitive districts calculating whether the protection is producing net positive or net negative electoral outcomes. All of that is real. All of it is documented. All of it is significant. What it does not yet constitute is the specific 3-factor Nixon convergence. The Supreme Court has not eliminated legal protection over decisive criminal evidence in the way United States versus Nixon did. The congressional mathematics have not reached the terminal point Nixon's had reached by August 1974, and Republican leadership has not withdrawn partisan protection in the explicit, direct, face-to-face manner that Goldwater, Scott, and Rhodes delivered on August 7th. November 2026, the actual decision point. Here is the honest analytical conclusion that the documented record supports. November 2026, the midterm elections, is the actual structural decision point in this trajectory. Not because the elections themselves resolve the legal questions, but because the elections directly affect the congressional mathematics that constitute the second Nixon factor. If Democrats gain House control in November 2026, the impeachment mathematics change fundamentally. Articles of impeachment become passable. The question then shifts to the Senate, whether 17 Republican senators can be moved, which remains the hardest documented threshold in this entire analysis. If the documented pattern of Supreme Court constraints continues developing through additional rulings that approach the elimination of specific legal protections Trump is relying on, the first Nixon factor develops further. If the economic underdelivery continues and approval ratings continue declining, the partisan protection calculation changes for Republican members in competitive districts, creating the conditions, though not yet the reality, of the third Nixon factor. None of that is resignation on the horizon as a present tense conclusion. All of it is conditions developing that could, if they continue on their documented trajectory, eventually produce the specific convergence that makes the Nixon parallel genuinely predictive rather than historically suggestive. There is an important distinction between those two things, and that distinction is the entire analytical project of this channel. I am not telling you the situation is fine. The documented record demonstrates unambiguously that it is not fine. I am telling you that not fine and terminal are different analytical conclusions, and that conflating them in either direction produces a distorted picture of what the institutional record actually shows. The pressure is documented and real. The convergence is not yet documented. The trajectory points toward a decision point in November 2026 that will either accelerate or arrest the development of the factors that matter. Watch the specific factors. Not the headlines, not the drama, not the historical aesthetics of who this reminds you of. Watch whether the Supreme Court eliminates a specific legal protection over decisive evidence. Watch whether the congressional mathematics approach the Nixon threshold. Watch whether Republican leadership begins to signal, privately or publicly, that the protection is no longer politically sustainable. Those three things, specific, documentable, historically grounded, are what actually matter. And right now, the honest assessment of the documented record is one factor is developing, one is far from threshold, and one is largely absent. That is the picture. Complicated, honest, and grounded in what the record actually shows. Let me close with the same discipline I applied at the opening. I told you at the start that I was going to tell you something you would not hear from most political commentary channels. The Nixon parallel might be wrong. Or, more precisely, the Nixon parallel is instructive in a specific, limited way, and misleading in the way most commentary uses it. Here is the precise version of what the documented record supports. The Nixon parallel is instructive as a framework. It identifies the three specific factors that, when they converge at sufficient intensity, produce presidential resignation, Supreme Court elimination of legal protection over decisive evidence, congressional mathematics becoming untenable for conviction, and partisan leadership explicitly withdrawing protection. That framework is historically grounded and analytically useful. It tells you what to watch and what threshold each variable needs to reach. The Nixon parallel is misleading as a conclusion. When it is used to signal that we have seen this before and we know how it ends, that the documented pressure on this presidency will inevitably produce the same outcome, it is doing something that the documented record does not currently support. It is projecting a predetermined ending onto a situation whose outcome is genuinely uncertain and depends on specific variables that have not yet reached the required thresholds. The documented record I have reviewed across every episode of this series tells a consistent story. Multiple independent institutions are simultaneously reaching convergent documented findings about the same fundamental conduct. Courts, military leadership, professional organizations, the Chief Justice, independent appellate panels, all producing documented assessments that point in the same direction from different institutional perspectives. That convergence is real. It is significant. It is without precedent in scale and density in modern American history, and it does not yet constitute the specific three-factor alignment that produced August 9th, 1974. The distinction matters, not because the situation is acceptable. It is not. And the documented record makes that unambiguous. But because honest analysis serves you better than comfortable confirmation of what you already believe. And honest analysis of the documented record says the trajectory is real, the convergence is developing, the decision point is November 2026, and the outcome is not yet determined. What you do with that information is your decision. What I will do with it is keep watching the specific factors, the Supreme Court rulings, the congressional mathematics, the Republican leadership signals, and report what the documented record actually shows, rather than what would be more satisfying to say. This is Matthew John Turner. The question I'm leaving you with today is not, will Trump resign like Nixon? That question is premature, and the documented record does not support a confident answer. The question is, do you understand the 3 specific factors that would actually have to converge at the documented intensity that August 1974 required for that outcome to become structurally possible? And are you watching those factors specifically, or are you watching the drama? Because the drama will always be there. The specific factors are what actually matter. Read the DC Circuit ruling, read the Engoron judgment, follow the congressional vote counts, watch the approval trajectories, and when November 2026 arrives, you will understand what the results actually mean for the institutional record, not because someone told you what to think, but because you followed the documented evidence yourself. That is what this channel is for. I will see you in the next one.